Good afternoon, everyone. First of all, my sincere apologies for not being able to be there with you in person. I would have loved to, but unfortunately, I have other commitments here at my university that prevent me from traveling right now. As Professor Sobczej has kindly introduced, my name is Almenar. I am a PhD in civil law at the University of Valencia in Spain, and today I will talk to you about the EU law primacy doctrine in the protection of fundamental rights, re-examined through the lens of constitutional pluralism. And I will seize the fact that it's been a decade since the Melloni judgment came out, and of course, the importance it holds for our Spanish doctrine. The doctrine of primacy of European Union law is, as you know, one of the defining features of the EU legal order. Since the landmark judgment in Costa versus Enel in 1964, the Court of Justice of the European Union has insisted that union law prevails over any conflicting national provisions, including constitutional norms. This claim has been described as the keystone of European legal system, because without primacy, the uniform and effective application of EU law could not be guaranteed. Yet this principle has never been uncontested. National constitutional and Supreme Courts have generally acknowledged its importance for European integration, but have also insisted that their constitutions retain ultimate authority, especially when the protection of fundamental rights is at stake. The result is a structural tension that continues to shape the relationship between Luxembourg and the highest courts of the member states. Conflicts in this field usually fall into two different categories. On the one hand, EU law may provide more extensive protection of rights than a national constitution, which can raise difficulties of acceptance at the domestic level. On the other hand, and more problematically, national constitutions may guarantee higher standards than EU law allows, which directly challenges the authority of the Court of Justice and threatens the uniformity of union law. It is this second type of conflict that has been most significant in recent years and that lies at the heart of the Melloni case. For those of you who are unfamiliar with this case, Melloni concerned the execution of a European arrest warrant issued for a conviction in absentia. According to the Spanish Constitution, such convictions could only be enforced if the person had the possibility of a retrial. The relevant EU framework decision, however, allowed enforcement provided that the defendant had been represented by counsel. Here, the Spanish Constitutional Court referred the matter to the CJEU, asking whether Article 53 of the Charter of Fundamental Rights permitted Spain to apply its higher constitutional standards. And the court's response was categorical. Article 53 could not be interpreted as granting member states the possibility to apply higher standards whenever EU law had already harmonized the matter, because to allow this could undermine the privacy and uniformity of EU law. Accordingly, Spain could not rely on its constitution to impose stricter requirements. And this judgment was groundbreaking because it reinforced the primacy of EU law even in the sensitive area of fundamental rights protection, while simultaneously curtailing the discretion of national constitutional courts to insist on their own higher protection, which has had significant repercussions. For the Spanish Constitutional Court, it meant accepting a clear limitation of its interpretative autonomy. But for other constitutional courts across Europe, it also raised concerns about the extent to which the national constitutional identity could still be safeguarded within the Union. The German Federal Constitutional Court particularly has developed the most elaborate response to this dilemma. Through the well-known Solange jurisprudence, it has declared that it will refrain from reviewing EU acts as long as fundamental rights are adequately protected at the Union level. At the same time, it has reserved the power to declare EU acts as ultra vires when they exceed conferred competences. a position made explicit in its case law from Maastricht to Lisbon and reaffirmed in its PSPP judgment of 2020. Finally, it has developed the doctrine of identity review, according to which certain core principles of the Basic Law are non-transferable and must be safeguarded even against EU measures. These mechanisms illustrate that Germany does not accept primacy as unconditional, but only on terms consistent with its own constitutional order. Italy, for example, has followed as well a similar path, but with its own doctrinal language. In the Taricco saga, concerning the disapplication of national limitation periods in cases of VAT fraud, the CJEU initially demanded that Italian courts set aside domestic rules that hindered effective prosecution. The Italian Constitutional Court responded that statutes of limitation form part of substantive criminal law and are therefore protected by constitutional guarantees. The ensuing dialogue between the CJEU to soften its position and the corresponding constitutional court led this former to accept that national constitutional identity could be taken into consideration. This episode showed that judicial confrontation is not the only possible outcome, but genuine dialogue and adjustment are also possible. France and other member states have also underlined the importance of constitutional identity. In some cases, particularly Poland and Hungary, the notion has been invoked more radically to resist EU law altogether, raising serious questions about the rule of law within the Union. These examples demonstrate the diversity of reactions to the doctrine of primacy and the persistence of constitutional resistance in various forms. The broader theoretical framework that helps make sense of these tensions is constitutional pluralism. Unlike a hierarchical system with a single ultimate authority, the EU legal order is pluralistic. Both EU law and national constitutions claim final authority, and conflicts between them are managed through interaction rather than resolved once and for all. The preliminary reference procedure here is the key mechanism for this interaction, allowing national courts to engage in dialogue with the CJEU when considered necessary. Yet its use is ambivalent. Sometimes it fosters cooperation, as in Taricco, but at other times it becomes a battleground, as courts submit questions to test the limit of the court's authority or simply to refrain from making references to avoid potential conflicts. In my opinion, here the Melloni judgment left open two fundamental questions, and that's why I considered it was interesting to revisit it after 10 years. First, is the relationship between Luxembourg and national constitutional courts genuinely dialogical, with all actors on an equal footing? Or are we talking about it being essentially vertical, with the CJEU positioned as the final arbiter? That would be one question. The second one, is the preliminary ruling procedure still an effective tool for ensuring uniformity? Or has it been transformed into an instrument of contestation? Well, the PSPP ruling of the German Federal Constitutional Court demonstrated how fragile the system can be. For the first time, a constitutional court openly declared a judgment of the CJEU to be ultra vires. And this challenged not only a specific act of the Union, but the very principle of primacy itself. At the same time, as I was commenting, as other courts, such as the Austrian Constitutional Court, have shown that constructive engagement remains possible. Austria asked whether widespread higher standards of protection in national constitutions could influence the interpretation of the Charter as part of the common constitutional traditions of the member states. This question suggests that pluralism may enrich the European standard without necessarily undermining primacy, provided it is channeled through genuine judicial dialogue. Looking ahead, the central challenge, in my opinion, is how to reconcile the principle of primacy with respect for national identities. Several avenues have been suggested. Strengthening informal exchanges among constitutional judges could be one, thereby creating mixed constitutional chambers to resolve disputes, or cultivating what some scholars call a constitutional culture community in Europe, based on a mutual recognition rather than hierarchy. What matters is to avoid both extremes, neither an unconditional supremacy of Luxembourg, which risks alienating national courts, nor absolute constitutional resistance, which risks fragmentation of the Union's legal order. 10 years after Melloni, the doctrine of primacy remains indispensable for the functioning of EU law, but it is not and has never been absolute. National constitutional courts continue to assert their role as guardians of fundamental rights and constitutional identity. The challenge is to transform inevitable conflicts into constructive dialogue. And here, constitutional pluralism provides a useful framework for this, recognizing that multiple authorities coexist and that legitimacy arises from their interaction. The European project depends not only on the authority of the CJEU, but also on the willingness of national courts to participate in a shared constitutional space. The lesson of Melloni is therefore twofold. First, primacy cannot be abandoned, but neither, secondly, can be pluralism. The future of European integration lies in sustaining this delicate balance through cooperation, respect, and, of course, an ongoing judicial conversation. Thank you so much. I remain open for any questions. You can reach out by LinkedIn or to my email, and I wish you a successful and very fruitful discussion and conference. Thank you.